Good afternoon, morning, evening, whenever you're watching this. Not legal advice with a K. Please like, subscribe, share, comment, whatever. I will, if I see comments, I will respond. Going to talk a little bit about the status of the pay package litigation post the vote in Texas, at least as far as I see it. Obviously, not legal advice. I do have, I've been a practicing attorney, have trial experience, very familiar with litigation. So even if I'm speculating some, it's based upon my prior experience. And we will see. I'll let you judge accordingly. Before I start, and as I do in every video, just a quick couple of points. I once told Farzad that the band Garbage once trashed their own studio. He said that was rubbish. 99% of lawyers give the other 1% a bad name. And why is abbreviation such a long word? Anyway, very interesting questions there. Anyway, before I go on, so I wanted to refer to the current status of the pay package litigation. I know it's kind of confusing. I see on X, I see all kinds of opinions, and I'm not going to say what the correct opinion is because mine is just another opinion. But I kind of wanted to give you how I see it as of today after the vote in Texas and what to expect. And this is just my view. So the trial, the underlying trial in Delaware that we were that in which the vote was reaffirmed, the pay package. The only issue that remains is the issue of attorney's fees. So there are ongoing briefs with regard to attorney's fees, but the underlying substance of the case were already decided. That trial ended about a year ago. So we're at the very end, the attorney's fees. And for the record, until the attorney's fees are decided, there is no final judgment. So that's what we're waiting for. And as you know, because I think it was discussed, there have been briefs filed. The Chamber of Commerce filed, the USA Chamber of Commerce filed a brief against the attorney fee request of plaintiff. And by the way, just so we have our vernacular correct, plaintiff is the party bringing the action. So in this case, it would be Toretta, and a defendant is the party that's accused of wrongdoing. So when I use those terms, that's what I mean. And when somebody else uses those terms, they should use those consistently. So the Chamber of Commerce filed a brief, a friend of the court brief, supporting the position that the attorneys for plaintiffs should not get a big fee award. And that follows Amy's request that was filed, an objection that was filed to the attorney's fee request, and CalPERS, which is a big union, I think it holds about $500 billion in assets. It joined, so in other words, it just literally joined the position presented by Amy. That means they're not filing a separate brief. They're just adopting the position of Amy. That's joinder. You could also file an opposition, and there have been oppositions filed. That's actually a separate brief. So both have been are ongoing. And so I've seen the reference. Some have referenced the issue of reconsideration in light of the June 13th vote, which reaffirmed Elon's pay package. And a motion for reconsideration generally is a motion in which you provide the court or a judge new facts that weren't available before, and you try to convince the judge that based on those new facts, a different decision should be instituted. Now, I'm not counsel for anybody here, and anyone can try anything. And counsel involved are very smart. And they may have many strategies that I'm not aware of. But let me address some of the legal concepts that are applicable on motions for reconsideration, et cetera. And before I start that, let's put this in context. So the Delaware court, to my personal dissatisfaction, when this action was proceeded because they deemed Elon to be in a conflicted position because he was a beneficiary of the pay plan, as opposed to a normal case in which the burden of proof is with the plaintiff, the party bringing the case. Because of the conflicting situation in Delaware, it's permitted to shift the burden of proof. So in the case, the underlying case in front of Judge McCormick, Elon, not the plaintiff, had the burden of proof. That is a problem that makes it difficult, much more difficult on the defendant to prevail. On top of that, the court decided, again under Delaware law, that as opposed to the business judgment rule, which is a rule that states basically, if you're an officer and director and you make a reasonable undertaking and you use reasonable judgment in making a business decision, that decision will be upheld. And there is, under some rules in Delaware, that would be the same standard that's used. But in this case, because again, the conflicted situation that the court found Elon to be in because he was the beneficiary of the pay package, they used the entire fairness doctrine, which is much more stringent against the defendant in this case, Elon, than would be the business judgment rule. So there were two factors. One, the burden of proof was switched, and two, the standard was higher. So it made it very difficult under those circumstances for Elon to prevail. And I'm sure on appeal, if it goes to appeal, and I think it will, those issues, amongst many others, the standard of proof, the flip standard of proof, issues about due process perhaps, those will all come about and be adjudicated. But it's basically the case that the standard of proof was not fair or did not help Elon. And in Texas, just to contrast the situation in Delaware, in Texas, the business judgment rule is the standard. So let's say tomorrow, since Tesla is now incorporated in Texas, if there was a decision about his pay package going forward, that would be judged by the business judgment rule in general. Not a Texas attorney, but that's the general picture. So that the ability of Elon or Tesla, a pay package to withstand scrutiny by a court in Texas, will be much higher and much more in Elon's favor going forward. Not legal advice, of course. So in this particular case, now we're going back to our Delaware case, after plaintiff Toretta filed their petition for attorney's fees, so the attorneys for Toretta seeking approximately 29 million shares, equating to almost $6 billion, which would be a historic award in Delaware by about a factor of 20. After they filed their motion, but before there were any oppositions filed to the motion, they filed a bunch of motions with Judge McCormick, in effect seeking to block any attempt by Elon or Tesla to undertake any action that would unwind the judgment of the court in that trial. And there were a bunch of briefs filed. And in essence, in the briefs, because it's summarized in the court letter dated May 28th, but in the briefs, they basically said, at least apparently said, Tesla's counsel, that they would live by the existing. They didn't agree with it, but they weren't trying to undermine the court's ruling in the trial, at least as to the responsibility, et cetera. And that they, in light of that, there was no need for these motions that would have blocked actions taken by Tesla in terms of it would force them not to litigate. There were a bunch of requests that were made, and we don't know if they would be granted anyway, but there were a bunch of requests made. There was a response by Tesla and others saying, don't worry about it because we're not trying to undermine the court's ruling. On May 28th, the court sent out a letter, the court being Judge McCormick sent out a letter. In the letter, it says, because everybody said we have nothing to worry about, I'm going to deny the motions of plaintiff that are going to try to block certain actions by Tesla. And since everybody tells me they're not going to undermine my ruling in the trial, then there's no worries. So that's what exists. So with that in mind, even if reconsideration were proper, in light of that exchange between the court and the parties after the petition for attorney's fees was filed, if now a petition to reconsider the ruling was filed, that would seem to be inconsistent with that. And I think the court would find that, rightfully or wrongfully, because obviously Judge McCormick seems to be biased against Elon. But the court would likely take that as being a false statement by counsel and might try to incorporate that into her ruling so that on appeal, that issue would not be favorable for Elon. So as a result, even though people say that, or some people are suggesting reconsideration, I don't see that in the cards at all. And on top of that, in a trial, what happens is you have a trial, and let's say you've put on your witnesses, but you want to add additional witnesses, but let's say the testimony is closed. You could make a motion to reopen. There's other post-trial motions you can make, but a motion for reconsideration really would not be applicable. And you have to distinguish between the original vote and the reaffirmation. The trial relates to the original vote. The reaffirmation is new. The judge can do whatever they want, but the judge is not supposed to act as a party. So no one has challenged the reaffirmation. Until the reaffirmation is challenged, it's valid. So, and that's my view, not legal advice, of course. But so to the extent that people think the judge would deal with the reaffirmation, the judge should not deal with the reaffirmation because that issue's not before her, and she doesn't have the right to act as a designee for those that might be harmed. So I don't think the reaffirmation will be discussed now. And in terms of reconsideration, I don't think it applies in this case. And if it was used, I think it would be in my opinion, it would be interpreted negatively against Tesla and Elon. So I wouldn't pursue that way. And just to give you an example of what really reconsideration would be, reconsideration is when you get new facts. You didn't have facts. So let's say, for the sake of discussion, in California, because I've obviously filed motions for reconsideration before, but let's say I have a case and it's about chocolate pasta, and somebody files a motion to dismiss or a demur in state court challenging my case about the chocolate pasta. And let's say, based upon the facts that I allege and the information I have, I lose and my case is dismissed. But let's say 7 days later, I get this secret email that has this important information about the chocolate pasta case. And that important information, if I would have had it before, would have changed the court's decision. Then, as long as I do it within 10 days of the decision or the day I received the decision, I could file a motion for reconsideration. That's kind of what reconsideration is used for, not for saying that the situation has changed. Again, although any attorney can argue anything. And again, in this case, because of the communication between the court and counsel that there would be no attempt to undermine, I just don't think reconsideration would be on the table, although, again, someone could have a different opinion. So if you're interested, take a look at that May 28th letter, because it kind of summarizes some of these issues. Again, there could have been other motions. There might be other motions filed post-trial. There could have been a motion to reopen. There may be some post-trial motions trying to change things, but I do not think there'll be any attempts to circumvent the judge's ruling, nor do I think it's necessary. So depending on the result of the attorney's fees, and we get a final result, and what's going to happen is, so there have been briefs, there may be additional briefs. Obviously, anybody who has an interest can file a friend of the court brief, an amicus curiae brief, and the court, if properly filed, and you have to request that the court consider it, the court consider it. So anybody who has counsel and wants to file it, certainly can, although the time is running short. Then there will be a reply brief from plaintiffs' attorneys, who I obviously have the most to gain in this matter, the only party that gains. That'll be sometime this month. And as of now, there was a hearing scheduled July 18th to determine attorney's fees. If in fact that goes forward and there's a ruling, I expect a ruling within 30 days. So we're expecting perhaps a final judgment August of 2024. If there's an appeal, because somebody's going to file an appeal, Tesla, Elon might file an appeal, the decision, underlying decision. There could be an appeal of the attorney fee award. The plaintiff's attorneys, especially if they get a substantially lower attorney's fee award, they might file an appeal, because again, this is a case run by plaintiff's attorneys and only benefiting plaintiff's attorneys. So I would expect them to contest this as far as they could. So Elon will still get his new pay package. Hopefully that pay package will have a premium built in. And I'm referring to the Texas pay package, not the reaffirmation of the original Delaware package. But in that pay package, I would expect and hope that Elon gets some premium for the remaining risk out of Delaware. So, and I'm just making up numbers, but if he was going to get $1, perhaps he should get $1.50 to reflect the issues that still remain in Delaware, because we could have future litigation in Delaware. We don't know what's going to happen. And what's important is that future pay package, let's say running from 2024 forward, would be interpreted by Texas law. And again, as I mentioned, that would be under the business judgment law, which would be most likely to withstand. So it's most likely that not legal advice, of course, but it's most likely that Elon's pay package in Texas will withstand any scrutiny. Someone could challenge it. Someone could challenge it in Texas. Someone could challenge the move from Delaware to Texas. There was a case involving TripAdvisor in which there was a challenge of a move from Delaware to Nevada. The court said no, but said under certain circumstances, perhaps. They didn't identify what those circumstances were, which could be a problem in of itself, but we shall see. But I expect additional litigation. So to the extent that you see lawsuits filed in Delaware, don't let that sway your view or make you concerned. Again, there's a lot of money at risk, and those plaintiffs' attorneys, they're after it like a rat chasing cheese. There is also, I would expect, at some future point in time, perhaps somebody, maybe another plaintiff working with these same plaintiffs' attorneys, might challenge the ratification separately. I'm expecting that at some point in time, and it would naturally seem to be these attorneys that would be the ones. Somebody might challenge the Texas pay package, but again, I think that's unlikely to be overturned. So if there's an appeal of the ongoing case in Delaware involving the original vote, not the ratification, I'm hoping the Delaware Supreme Court will recognize that this whole issue is harmful to the state's treasury because it will materially influence the income, I believe, that Delaware will get in the future because companies will move. There obviously are companies that are already moving. And I don't believe Delaware has a great amount of industry. And at least when I started in law school way back when, the companies pretty much only incorporated Delaware, paid fees there, et cetera, and that generated a lot of income for the company. I'm hoping that when the Delaware Supreme Court, which would hear this appeal, especially if the award is ridiculous, sees that it's impacted the economy of Delaware, that they will act practically and either overturn the ruling or revise the ruling or send it back for further consideration. It may be the case if that was done that Judge McCormick's not even on the bench and a different judge might be considering that. We'll have to see how that plays out. So, kind of to summarize, the current matter, the current trial, the issue that's ongoing is the attorney's fees, which is processed. That's ongoing. After a judgment is final, within 30 days or so, someone's likely to file an appeal. It either be Tesla, Elon, or Toyota. If that happens, let's say in August, the appeal would take likely approximately 9 to 12 months. That would be August of 2025. If that appeal concludes the matter, then so be it. If it does not, and someone has a constitutional ground to take it up to the US Supreme Court, and the Supreme Court accepts the case, because the Supreme Court doesn't have to accept all cases. And if they do, there has to be some constitutional argument or some federal statute that's involved. And in this case, I do think it's going to relate to something involving due process, involving the burden of proof and the flip of that, something rising out of that. But to the extent that this case needs to go to the US Supreme Court and it followed the timeline I just mentioned, then it's likely it would go in the fall of 2025 and you get a decision by June of 2026 if it follows that pattern. The reaffirmation that just occurred in the Texas vote, that's lawful until found otherwise. And again, I don't believe the judge has standing or that this matter involving the affirmation is before her at this time. And as far as I'm concerned, she should not rule on or discuss the reaffirmation. And the only way that reaffirmation could be challenged is by someone bringing an action at some future point in time, which may happen. But obviously it's a different position. Everybody knew the facts, as opposed to perhaps in 2018, you could claim otherwise, but there's nobody who did not know what was going on who voted. All you had to do is have an open ear and you understood what the position of the other side wasn't hidden. So the voting related to the reaffirmation, I think, is much stronger than the prior voting. The 2024 pay package thereafter will be governed by Texas law, and additional litigations likely to be expected, so don't get blown out of shape just by seeing that, but that's likely to happen. And again, I don't think any kind of reconsideration will occur because of the pleadings that happened between after the attorney's fee motion was filed and the reassurances that the court was given about nobody trying to undo her decision regarding the original vote. But if the reaffirmation takes care of the same terms that were in the original vote, then so be it. The reaffirmation stands. So hopefully that clarifies where we are today. It deals with the reconsideration it distinguishes between the original vote and the reaffirmation. It indicates that future pay plans are governed by Texas law, that the standards in Delaware and Texas are completely different. And I hope that clarifies things for you. If you have questions, concerns, comments, please reach out. Be well, everybody. Take care. And if as this case goes on and as it's decided, I will try to add some more color.